end said public prosecutors are expected to be public prosecutors, not persecutors. My friend Manoj is one of the fairest lawyers we have. I think he should assist the court on point of law. The police officers will give various instructions from behind, but he has the experience and the sagacity, my lord, to disregard and rise above that to assist your lordships. I'm grateful.
With regard to that, I never said that lunch motion cannot be moved. What I said is, having rejected the lunch motions at 10:30 for various advocates, not on various reasons, if the benefit is extended to a common man, it will give a good impression. But it gives wrong signal. That is what I was saying. But I never said that no lunch motion can be moved. Even they can move on Saturdays, Sundays, but at any time, if there is any problem, that they can knock the doors of justice.
Yes. This public prosecutor, now they have placed some orders where it 482 interim orders were granted for the releasing of the.
Whatever
what do you say on that?
Yes, whatever the land senior counsel.
No. On
No,
this,
it is not. The facts is different, Each case, facts is different.
I can now release the petitioners or not who, if they are arrested in view of these orders which have been placed by the learned senior counsel.
I'm
I
sorry.
think you have handed over those orders.
Yes, all judgments have been passed on.
What do you say on that?
Judgments, Judgments.
Whether I can release the petitioners now
Whatever the judgment.
in quash petition.
Yes, I'm.
First you answered me.
Even my humble submission, they moved the present application by way of lunch motion at 2:20. Kindly see what they are seeking. They are seeking the quashment
about that. When they moved lunch motion, I have
without,
that is my priority. That is
without now again they
I'm
moved.
asking whether in 482 can I pass an order for release?
No, it is not. It is at that juncture. At that juncture, it is not the accused not entitled to move any application in the way of IA in the criminal quash petition seeking the regular bail. Separate forum is there. There is a provision to approach the
No, their other argument is without even moving IA, orders were granted in criminal petition under 482, where the accused were released.
Even my humble, even remand report is not before your lordship.
Remand report issued on your
one more fact, kindly see,
FIR is before me.
FIR
and your instructions are there, they are arrested. What else?
Arrested, now so far, even accused, not accused counsel not produced remand report. Kindly see 105, 105
not
very
required.
much.
Not required.
1 minute, 105 very much applicable to the accused. Kindly see, 106 land council read but we are with the 105.
105.
105 BNS
Yes, sir.
105. The punishment for from the starting, punishment for culpable homicide not amounting to murder. Whoever commits a culpable homicide not amounting to murder shall be punished with the imprisonment for life or imprisonment of either description of term which shall not less than 5 years but which may be extended to 10 years and shall also be liable to fine if the act by which death is caused. Hereafter it will intention of the causing death or of causing such badly injury as is likely to cause death or with the imprisonment either description for a term which may be extended 10 years. This is applicable likely to cause death or which imprisonment. This is the 105.
Which is applicable to the petition.
Yes,
which ingredient is applicable to the petition?
This knowledge.
How many times we read the entire section there is no use.
Next limit, my lord. Next limit.
No, you said
Description.
105 will first conclude, then we'll go to 106.
No, I am not going. Only 105 I am reading. I am permitted to read. Description for a term which may be extended 10 years with fine if the act is done. Next minute. If the act is done with the knowledge that is likely to cause death. In this case, he is having the knowledge that is, but without
What
any
knowledge is having?
there would be a heavy crowd, huge crowd.
He is having knowledge, there will be huge crowd. As for that, he has taken permission.
Not
From the concern.
Permission.
Yes, they have placed
Permission
the
rejected. I will place the lordship
They
initially.
have
Permission
the
rejected.
police, they have accorded permission. But your instructions, sir, they have informed them not to go to the theatre, but there is no material
Please.
placed by the
I will place, my
prosecution.
lord. I will place. I'm sorry, my lord. Once again, I may permit to submit. They filed the just request before the concerned ACP, sought this permission. That representation. Permission neither granted by the any officer. Just they filed the application. They are showing the endorsement which was given by the concerned ACP office. Does not mean that the
Human copy of the petition. Not audible, sir. It's not audible, sir.
I think you understood.
My lord, I think the remand report makes my case better. I just got a copy, my lord, on WhatsApp, so I took a print. In this also, my lord, none of the ingredients of 100 are mentioned. They are only saying the management should have been more careful. They should have taken the actor on a separate, they should have provided separate access and taken him separately. Because of him coming, there was surge. But Losses may kindly see, my lord.
So there is no awareness of that the permission was cancelled or they have
No, nothing. I'm going to remand report, second page. At the time they mention, the drastic incident occurred on Sandhya 70 having so much capacity. After two sentences, they say, later on about 9:40, the hero Allu Arjun and his family and personal security, 12 to 16, entered into the theatre premises. On seeing him, all of a sudden, crowd started approach towards A11. Security personnel 12 to 15 and others of A11 pushed them away forcibly, due to which mob entered into the lower balcony of Sandhya 70. As a result of heavy rush, deceased and her victim's son got suffocated. So, my lord, the security were only protecting the hero by keeping the crowds at bay. My lord, eventually, my lord, if I am, because I have gone to that theatre thousands of times, I can't speak from a personal experience. My lord, people, when someone is going into one balcony, my lord, when you push, they don't go into the lower floor. What really happened, your leadership seems to be, police were intimated, police were present, they were not in adequate numbers. And now who is conducting this prosecution, your lordships would see, would be everything will be done by the police. So they would want to blame everybody except taking negligence on their head. And my lord, if my learned friend is right, I will suffer a trial.
Insufficient police officials were there, so they couldn't control the crowd.
That's correct, your ladyship. And in fact, the remand report says, after the lady and the child fell and they were crying, police came from first floor to ground floor. That means there were no police in ground floor. They also want to see Allu Arjun only on the ground floor. If your ladyship sees, my lord, cricket matches, in India, police officers are all watching cricket match. Abroad, your ladyship feel all police officers will be watching the crowd. Everybody wants And eventually they want to now arrest me because they will also see me in the police station. They will sit with me.
Ultimately, the police only shifted the
But also, my lord, the leadership would be guided by one factor, which is eventually, if the leadership is not going to quash, I'm sanguine we'll get it to be quashed. If leaderships are not persuaded or the court is not persuaded, I will go to trial, and if they're able to prove their case, I will be subjected to a punishment. But why should they take? What is the inquiry they can do? Not custodial interrogation or inquiry?
No, at first instance, whether ingredients are applicable,
Absolutely.
satisfying offense
That's
to the
right.
petitioner,
That's right.